Mr. Obert Nolte. We have a little bill on daylight savings.
It's kind of lonely at this table by myself.
I know the feeling. The floor is yours.
Mr. Chair and members, presenting AJR 28 today. As we all know, twice a year, California observes daylight savings time, and we switch our clocks 1 hour. And this is an anachronistic practice.
Move the bill.
Thank you very much. Recent studies have also indicated that it has serious consequences on our health. So, for example, the risk of heart attack and stroke is substantially greater in the day following the time zone change. The risk of car accidents is greater, the risk of workplace injuries is greater, and the rate of suicides is substantially higher. So the original reasons why daylight savings time was enacted was for energy conservation. However, studies indicate that those goals are no longer being met by the observance of daylight savings time. There's a bill by my colleague Assemblyman Chu that is pending in the legislature that would put the issue to the voters to take California off of daylight savings time entirely. And I think that is better than the status quo. In fact, I'm a co-author of that bill. However, there is another option for us, and I think that it would behoove our constituents to at least consider it. The Federal Universal Time Act allows states two options when it comes to the observance of daylight savings time. Either you can not observe daylight savings time, or you can observe daylight savings time. However, if you do that, you must observe daylight savings time between the date that the federal government sets. There is currently not an option for states to permanently observe daylight savings time. However, there's some pretty compelling benefits to doing that. There's been a recent study by the Rutgers University that reported that moving to a year-long daylight savings time would result in a 13% reduction in pedestrian fatalities, a 3% reduction in driver fatalities, and a 7% decrease in robberies. But I think for the state of California, the most compelling reason to go to year-long daylight savings time would be something that is especially concerning to this committee, which is the fact that we are attempting to move our energy generation to being supported by renewable energy. And I'm sure we're all familiar with the duck curve, which says that in future years, our energy generation is not going to line up very well with our energy consumption. And that's because primarily energy generation from renewable sources is going to occur within daylight hours. If we were to shift to year-long daylight savings time, that would go a long ways towards matching up that production with the consumption. So this resolution, AJR 28, would petition the federal government to pass a law allowing states the option of observing year-long daylight savings time. That would be the first step. The second step would be then for the state of California to pass a law moving to daylight savings time, and then that would have to go to the voters because currently the observance of daylight savings time in California is done through a ballot voter initiative, so the voters would ultimately have the say. So this is not actually taking any action, colleagues. All this is doing is giving another tool in our toolbox for figuring out what to do about this problem. And so I'd requestfully respect your aye vote and your support.
Terrific. Thank you. I just want to make sure you're accepted the committee amendments.
Yes, I am.
The resolution's been moved and seconded. Let's go to witnesses in support, opposition, questions or comments from the dais. Mr. Vice Chair.
Mr. Oberlin, thank you for bringing this forward. We had a conversation about some of the consequences. I'm going to gladly give you a courtesy vote today because it's the beginning of something. I will only point out that if California were to move to daylight savings time all year round, there are hundreds of radio stations in California that have a daylight power setting and a nighttime power setting. Stations I've owned and operated for years fall into that category. The reality would be that we would be at low power in December until 9 or 9:30 in the morning, which strips out our drive times completely. So there is obviously good cause for the matter that you're bringing before us, but it does create some real heartburn for people, particularly who are local owned and operated radio stations, most of which are not been grandfathered in by the 1934 Communications Act and which would be at a huge and significant competitive disadvantage if we were to go that far out all year long with permanent daylight savings time. It would be a crushing problem with respect to our competitiveness. But I understand what you're trying to do, and we'll gladly give you a courtesy vote.
I thank you for that, Assemblyman. I'm very aware that moving to full-time daylight savings time would definitely create winners and losers in California's economy. And I'm sure that if we had this tool, that we would all have a robust discussion about whether or not the individual losses outweighed the benefits to our collective society. I'm just trying to give us the tool to be able to have that discussion.
Terrific. And who knew there was a radio connection? But that makes good sense because I am aware of the differences in signal. So this bill, is something that I've talked with the other author, I believe it's Mr. Chu, and it's a complicated state of affairs. But I think this is an important conversation to have. So it enjoys a due pass recommendation, and you can close if you wish, or we can call the roll.
Please call the roll, Mr. Chair.
Thank you very much, Madam Secretary.
The motion is due pass as amended in the committee analysis to the floor. Gatto?
Aye.
Gatto, aye. Patterson? Aye. Patterson, aye. Berg? Chavez? Aye. Chavez, aye. Daly? Aye. Daly, aye. Eggman? Aye. Eggman, aye. Cristina Garcia? Eduardo Garcia? Hadley? Hernandez? Obernolte?
Aye.
Obernolte, aye. Quirk?
Aye.
Quirk, aye. Santiago? Ting? Williams? Aye. Williams, aye.
The resolution is passed, and we'll hold the roll open for add-ons. Okay, next I'm going to present two bills, the first being Assembly Bill 2763. And so I'm going to turn over the gavel to our illustrious Vice Chair. And
Mr. Chairman, please present.
Thank you very much. So the first bill that I have before the committee today is Assembly Bill 2763, which would define in statute the definition of a personal vehicle for people who use the transportation network companies' platforms. The bill simply defines a personal vehicle to mean any vehicle, whether it's owned, leased, rented, or otherwise authorized for use to provide prearranged transportation services. The bill preserves all existing inspection and safety requirements imposed by the Commission and maintains the ability for regulators to improve those safety requirements over time. What this bill does not do is adopt a time limit for the concept of personal vehicle, because as I think everybody would gather, artificial timeframes do not equate to public safety. The issue that this bill is trying to address, of course, is steps that the PUC has taken to prohibit people who otherwise are full-time employed from renting a vehicle from a rental car service and using it to drive for a TNC. I would just note that rental cars are subject to 19-point inspections at the point of return, whether even they were rented for one day or not, and also that rental car companies are under much stricter requirements than you and I. If our cars are recalled, we don't have to fix them. Rental car companies do. They do hundreds of recall fixes every year for things as tiny as little light bulbs in the brake lights. So this is a important bill, I think, for teachers and people who work during the rest of the summer. I ask for aye vote.
It's been motioned and seconded. And support witnesses?
Thank you, Mr. Vice Chair, members of the committee. Robert Callahan with the Internet Association here in support. I've also been authorized to pass along TechNet's support as well. They can't be at the hearing. The chairman has already said it very well. We support the bill. We think it provides those of modest means and ability to participate in ride sharing, and also sort of paves the way for environmental gains from all types of electric vehicles, et cetera, to be used with greater frequency in California. So for these reasons, we support the bill and urge your aye vote. Thank you.
Mr. Chair and members, Will Gonzalez on behalf of Uber and strong support.
Mr. Chair and members, Laura Basesto for Lyft. We ask for your vote, and we have strong support for this. Thank you.
Additional support witnesses, please.
Mr. Chair and members, Brian Rothery with Enterprise Holdings. We operate the Enterprise, Alamo, and National car rental brands, and we are in support of the bill.
Any others? Public support? Opposition witnesses, please.
Yes, it here.
Oh, yeah, of course. You're welcome.
Thank you. Thank you, committee members. My name is Mark Bruberg. I am a San Francisco taxi driver, drive for Green Cab, and a board member of the San Francisco Taxi Workers Alliance. This bill turns on its head the concept of a TNC and the initial justification for their existence. A space was made for this service next to limousines and on top of the taxi industry on the premise and the requirement that drivers would be using, and this is a quote, their own personal vehicle, not a vehicle such as a limousine purchased primarily for a commercial purpose. In defiance of that language and that requirement, Uber and Enterprise will rent a car to a TNC driver for as little as 4 hours. Lyft now has a rental program with General Motors. It's a company called Breeze that offers short-term rentals directly to TNC drivers. There are lots and lots and lots go up on the internet of casual rentals going on, one individual to the other for any period of time. There's a company called HireCar that acts as a broker between a person with a car and a person who wants to drive it. And HireCar says on its website that most of the vehicles on its system are not approved by Uber. What does that mean? And you can rent these for as little as a day. It means that the onus is on the driver who may be leasing this vehicle or renting it really for as little as 1 day to get that car inspected and approved by Uber. If the driver skips that step, gets into an accident in an uninspected car, is any insurance going to cover that claim? Certainly not any personal insurance unless the driver commits insurance fraud, which we know goes on, and pretends that they're providing personal, just driving the car personally. I doubt that Uber's insurance is going to cover that because you know, it's not been inspected. It's not part of the Uber system. And Uber has no way to know what car you're in. All they know is that you are registered on their app. So the monumental task of enforcement over these myriad arrangements falls upon the CPUC. And I'd ask if any one of you has the confidence in the CPUC's ability to protect the public in this area or really any other area where they have jurisdiction. So this is something that, you know, encroaches further on the narrower and narrower space that the taxi cab industry has. Taxi cabs are an essential public service. We serve people without smartphones, serve people without credit cards, take all kinds of payments, credit, debit, vouchers. The disabled community is dependent on taxi cabs. And as our field of operations narrows further and further and further, we are less and less able to provide the kind of service that the public wants. This is destructive competition by definition. So we ask you to oppose this bill, not support this bill, and I'll leave my remarks at that.
Yeah, hi, my name is Barry Korngold. I've been a legal taxi driver in the San Francisco Bay Area for over 30 years. I'm also on the board of the San Francisco Taxi Workers Alliance. I'd like to remind everybody that I was also on the rulemaking proceeding on the TNCs from its beginning, and I'd like to remind everybody that this proceeding started after Uber had defied the law and a cease and desist order for 2 years, and now laws are being enacted not for public safety or consumer or environmental protection, fair business or labor practices, but to conform with the TNC business model. TNC service mimics taxi, shuttle, and other already existing and regulated transportation modes, but are not held to the same standards. There's also been this double speak that's been created where on-demand is prearranged even if they don't take advanced orders. The reason this is significant is taxi service causes more congestion, pollution, and wear and tear to the roads. Whether you call it prearranged or on-demand, TNCs do the same thing, and they have the same effect on the environment and congestion. The GPS developer TomTom came out with a study that said San Francisco is now the second most congested city in the nation. Compared to 3 years earlier, it was number 5. The American Lung Association has a yearly report, and the San Francisco Bay Area was not even listed in the top 25 most polluted areas in 2013. In 2015, after the TNCs have come out, now we're number 7 in most year-round particle pollutants. This is being ignored. We can see it as drivers all around us. We're surrounded by these TNC drivers. If you're not out on the street, you don't see it, but now there's evidence indicating that what we're saying is true. And by doing this kind of leasing, allowing unfettered leasing, you know, their Uber put out an ad that they want to lease personal vehicles for 4-hour shifts. So is this still a personal vehicle? This doublespeak I'm talking about, now sharing is the same as charging money. You can charge money, but you're still sharing it. You can primarily use your vehicle for commercial purposes, but it's still a personal vehicle. So we urge you to vote no on this bill, as it's going to exacerbate this congestion and pollution problem and many of the other problems. Just because also. You can be exempt from all this regulation as long as you're not a taxi or a limousine, is what this bill says also.
Any other witnesses in opposition, please? Seeing none. Back here. Members? Yeah. Any questions of the author and comments? Would you like to close?
I ask for your vote.
Thank you. Members, what you wish? It's been moved and seconded? I'm sorry. Got it. All right, let's call the vote.
The motion is due pass to the floor. Gatto?
Aye.
Gatto, aye. Patterson?
Aye.
Patterson, aye. Burke? Burke, aye. Chavez? Dally? Dally, aye. Eggman? Eggman, aye. Cristina Garcia? Eduardo Garcia? Hadley? Hadley, aye. Hernandez? Obernolte? Obernolte, aye. Quirk?
Aye.
Quirk, aye. Santiago? Santiago, aye. Ting? Williams? Williams, aye.
So, your bill is out. Mr. Chairman,
Thank you very much.
Next bill.
Okay, the next bill that I have before you today is Assembly Bill 2867, which has to do with the cancellation of certain television contracts. I want everybody to imagine for a moment a world where a tenant in the state of California, somebody who is renting an apartment, wants to give notice to their landlord. And they give notice to their landlord, and they are forced to sit through a timeshare presentation. We've all sat through those timeshare presentations. You know what I'm talking about. An hour, 2 hours, where they tell you that the timeshare is the greatest thing since sliced bread, and you just want to get on with your life. Well, folks, that's the world that we have in the world of television. And the problems that have manifested over the years with consumers not being protected and having very, very aggressive sales tactics like that, and having consumers lose the most precious resource they have, which is their time, are the reason why this bill has been featured in Fortune magazine and Time magazine as the #1 consumer protection bill going on in the nation right now. Now, I want to go first into the definition of what this does. This would require, if a company offers the ability to sign up online, that it has the option, it provides the option to consumers to also cancel online. Now, what does cancellation mean? Cancellation is simply the ability to provide notice to the corporate entity that you want your service terminated as of a date certain. That's all that cancellation is. It doesn't affect, obviously, the fact that you have to make good on your bill, you have to come current on your bill, that you have to return your equipment. All of those things still have to happen. And those things might not happen online. They might happen by a mailed credit card payment. They might happen by going into the office and turning back in your cable box. But we think that if a company is offering how easy it is to sign up, that they should also make it easy for a consumer to give notice, just like that renter that I talked about, that the consumer relationship is done. That's one of the hallmarks of contract law. There has been so much bad information given on this bill that I feel like I need to address it in my opening. So a couple things that I want to go through first. We hear that this would be unprecedented and all this stuff about how this is really weird way we're having the relationship between a company and their individuals out there regulated. Well, that's total nonsense. We are tasked, as part of our police powers in the state, with consumer protection. Police powers don't just mean patrolling the streets. They mean protecting consumers from unjust practices. Examples, lemon law. We have a law on the books that says if you buy a car, and that's another time where, aggressive sales practices, car salesmen. If you purchase a car, you have 15 days, no questions asked, to return that car. And then obviously if the car you bought turns out to be a lemon, the state steps in and governs that relationship. We require Pep Boys to take back cores. If you buy a battery at Pep Boys, they've got to take back the battery and dispose of it. And that's just because we recognize that the average consumer does not have the ability to dispose of lead acid car batteries in their trash. We have do not call lists. We just talked about a bill that had to do with kind of the same thing. But those are all examples of where the state steps in and regulates the consumer protection relationship, and not just with oligopolies like the television companies. Second thing that I think has been said is that this bill does not apply industry-wide. Well, I would direct you to Section 1726 of the bill, which states in very, very clear English that this bill applies to both television companies and internet service providers. So all of the things that we tend to call in shorthand satellite, those things are technically called ISPs under the law, and this bill covers it in black and white. We already took that amendment. The other question that we hear is, why doesn't this apply to every single industry in the world? And my reply would be, well, someday I would hope it would. And I would hope that maybe some of you would run these bills as the years go by. One example would be, our leave system. We first had maternity leave, and then maternity leave was expanded, and then there was paternity leave. These things sometimes happen in steps. They don't happen all at once. I have chosen to do this in this bill. And I would also counter, and I would say, there are very other few industries that generate as many complaints. Yes, we live in a world that is complaint-driven. I hate to break it to you. The squeaky wheel gets the grease, the crying baby gets the milk. Those who have industries that have problems that are noted by Fortune magazine and Time magazine, which are not your typical, bleeding heart lefty publications, then yes, we have a problem that requires the legislature to step in and address. This is something where it's almost become so anecdotal that we don't need anything beyond it because there have been so many problems. The other thing that I will say on that is part of being a responsible legislator, in my book, involves telling an industry when they're right and telling an industry when they're wrong. Now, I've served up here for 6 years, and I have never been hesitant to tell an industry that it's right and to vote on the side of an industry when I think that they have the right position. But part of being a responsible legislature also means that you know and you have the courage to tell an industry that they're wrong. One example that I would give is something that also came up before this committee. I'm a big fan of the gas company. Los Angeles resident, their bills are so cheap. They deliver services really well. For years and years, I talked about how they were a model utility, and I contrasted them with other utilities. But when it came to the handling of certain things with the Porter Ranch disaster, I looked them in the eye and I said, you know what, on this one, guys, you're wrong. You're not doing things in the way that I think is best, and here's what I think is best. And I think that's really crucial for us to remember, that as legislators, we owe that to not just blindly accept what they say, even if we believe that they're right in many other times, but to tell them when I think that they could improve. And I don't think anybody could disagree that when it comes to customer service in this arena, these companies could improve. Third, You hear these companies say that, well, we just want to talk to our consumers. We just want an opportunity to show them what a great company we are. Well, I submit that you have that opportunity every single day. There are lots of people on this dais who are successful business people. They know that if you're offering, for example, Mr. Vice Chair, a radio product, you want to have good broadcasting every single day. You don't want to just wait until they change a channel and say, hey, come back. We'll hire a new host, I promise. No, you don't do that. We have other people on the panel who are seed farmers, and they give a consistent, good product. They don't come back and say, well, gee, my seeds were all irradiated and they didn't grow this year. Well, I'm sorry. Well, I promise that I'll give you free seed next year. No, you have an opportunity to talk to your consumers every single day and to treat them right. There shouldn't be a situation where you hear that your neighbor is getting charged 1/5 what you're getting charged, and then you call and say, hey, I'm upset, I'm canceling my service, and they say, oh, we can offer that rate to you. No, you can offer that rate to your consumers all the time, and I submit that you probably should if you're having problems. So when it comes down to it, this is a rather straightforward bill. If you believe that it would be fair for a renter who wants to cancel their lease, wants to leave their house, and that's a complicated relationship too. You have to give back keys. You have to give back your security deposit. You have to do a lot of things. But if you think that it's right, that we as a legislature should allow landlords to submit that renter to a 2-hour timeshare presentation, then don't vote for this bill. But if you think that this is an area of the law that we probably should be telling that industry, you can do better, we know you can do better, and that we should be protecting consumers and giving them back something that is so critical. It's the one commodity in life that only moves in one direction. You can't get time back. Then you should vote for this bill, and I ask for your aye vote.
Thank you. My name is Aaron Lewis with the Consumer Federation of California. We're in very strong support of the bill. I think that was very well said, but I'll just add that cable companies and internet service providers make it very easy to sign up for contracts online. They make it easy for customers to maintain and update their customer information, billing information. And yet, when it comes to terminating a contract, these companies put up significant hurdles. These hurdles provide an opportunity for cable and internet companies to aggressively market to consumers. The tactics are very well known, and customers are very understandably seeking a way to avoid these practices. Consumers should have the option to cancel online if they are provided with an option to sign up online. I would just note that I saw in the analysis that the opposition notes the bill could potentially provide a hurdle to retention efforts. The hurdle is bad service and aggressive, poor product, aggressive customer service, and that's what should be addressed. So this bill would just cover a matter of fundamental fairness, and so we ask for your aye vote. Thank you.
Before we ask, do we have members of the audience in support, public?
Good afternoon, committee members. Danielle Kando-Kaiser on behalf of the Electronic Frontier Foundation. We apologize. We did not get a letter of support in. We just started discussing this bill with the author's office, and we are in support of it.
Thank you.
Thank you.
Others? Mr. Chairman, before we go to witnesses in opposition, you do accept the committee amendments
Yes,
before us?
I do.
Which includes the satellite providers in the bill.
Yes.
Correct? Yes. All right, that's on the record. We'll go to testimony in opposition, please.
Mr. Chairman and members, Carolyn McIntyre on behalf of the California Cable and Telecommunications Association in opposition to the bill. I will start my presentation by noting that the bill does in fact discriminate by technology. It is not technology neutral. Even with the amendments that were just adopted into the bill still fails to impose the same policy on telephone companies. There are telephone companies that provide video service in the state of California pursuant to a law that was passed in California in 2006. It's known as DFCA. DFCA allows them to obtain a state franchise in order to provide video service in California. However, they are video service providers. They are not considered cable companies, and they are not, by their own interpretation, subject to the provisions of the Federal Cable Act. In addition, the bill fails to recognize that there are many reasons that a two-way communication is appropriate between a business and a consumer who chooses to cancel their service. Not only do we need to provide instructions on how one may go about returning their equipment, oftentimes there are bills to be settled. Oftentimes there are promotional packages that have been taken advantage of that a consumer may not realize is associated with early cancellation fees or retroactive payments to the extent that they cancel early. So there's plenty reason to have a two-way communication, which is very different than when a customer goes online to sign up for service. I will also note that the bill does, in fact, fail to recognize that customer retention is, in fact, a legitimate business practice. We want to know why a consumer is choosing to leave our service and to go elsewhere. And to the extent there is an opportunity for us to retain that customer by providing them with a promotional package, by being responsive in some other way to the complaints that they've had with our companies, we should be allowed the opportunity to do that, and the consumer should be allowed the opportunity to have that benefit. For those reasons, we oppose the bill, and we request your no vote.
Next,